first court date that somebody has in a felony is called their arraignment date. The arraignment date is a date by which the person finds out what charges are filed against them. The judge addresses any issues of bail or release. The judge can set an OR release, or the judge can ask for some amount of bail to be posted for the case to go on. The person's attorney is addressed. They can ask for the public defender, they could represent themselves, or they can have a private attorney who makes an appearance. Then we file what's called a motion for discovery. So any police reports that the person is asking for are exchanged at the first court date. And typically, the client enters a plea, which is a plea of not guilty. The plea can always be changed to a plea of guilty later, but these initial issues are usually addressed at the client's arraignment. So that's the first felony court date. Many people think that my first court date is going to be a full hearing in the entire case. The police officer is going to be there. I'm going to have to talk to the judge. It's usually a much shorter hearing. We appear, we say, we're your attorneys, we get your reports, and we set another date to come back to review the reports, to talk with the district attorney, and to negotiate your defense. Now, every person who's charged with a felony in California has a right to have a preliminary hearing within 10 days of their arraignment. The preliminary hearing is a contested hearing. That's where the district attorney has to present probable cause that you committed the crime. They could sometimes have the police officer testify, the victim of the crime. As your attorney, I have a chance to cross-examine those witnesses. And the judge will either say that there's probable cause and do what's called bind the case over, or the judge will say that there's no probable cause and not bind the case over. Sometimes we do not wish to have that preliminary hearing immediately within the 10 days. We want to have time to look at the police reports. We may want to even have intermediate court dates to come, file legal motions, talk about your case with the district attorney. Those cases have different names depending on what courtroom that you're in Los Angeles County, but the idea is basically the same. We're coming to court, we're negotiating the case, I'm speaking with the district attorney, we're dealing with any preliminary issues, but we're not arguing the facts of the case in front of the judge. Many times we can work out a deal or a plea at some of these early hearings. They could be called a pre-preliminary hearing, an early disposition hearing, or a DNR, disposition and reset. The point is the same. It's a date to come to court where we're not having a preliminary hearing and we're talking about the facts of the case. Now, several courts in Los Angeles County will order what's called a probation report between the arraignment date and some of these early initial hearing dates. And they'll have a probation officer draft a report which summarizes the facts of the case and the client's background, including work and criminal history. So that report comes into court, the district attorney gets a copy, I get a copy. Sometimes that report will even have a recommendation in terms of for a potential sentence for my client. And again, I look at the report and the judge looks at the report. The purpose of it is to give us an opportunity to maybe try and work out a deal or resolve the case at an early stage, since we've had the input of the probation officer and we know a little bit more about the case. If the client is interested and we can work out an agreement, then that will happen at those early dates. If not, then it goes to the preliminary hearing. Now, if a client goes and has a preliminary hearing, the case then has a second arraignment date where they are arraigned or they have to answer to the charges that the judge found probable cause on at the preliminary hearing. From there, there's typically more hearings, pretrial hearings, and if the case does not resolve either through a dismissal or a plea, the final stage of the felony court process is what's called a jury trial. So 12 jurors have to come in and make a decision whether my client is guilty or not guilty. Where we go in each stage of the process depends on the specific facts of each case and is a conversation that I have with each of the clients that I represent.